My name's Michael Levinsohn. I'm a trial attorney. I usually speak to about 12 people right in front of me. So I'm going to imagine that there are 12 people right in front of me right now, or everybody can move to the middle. Either way. How many doctors do we have here? How many lawyers do we have here? Okay. The reason I do that is because when I do a trial, I know a little bit about the jury before I start talking to them. I had thought about different ways to do this, and I think what I finally decided on, I don't think what I finally decided on, I know what I finally decided on, and I'm going to get my timer started so I know exactly how much time I'm taking, is, in simple terms, everybody remember the Glamour magazine back in I think it started maybe in the 70s or the 80s. They used to have the Glamour fashion do's and the fashion don'ts. So there were Glamour do's and don'ts. Well, we're going to touch on some of the more important medical, legal, cannabis do's and don'ts. There's your Glamour magazine. So when it comes to fashion, a do, as an example, is always consider basic black for a formal affair. Never go wrong. It was Coco and Chanel or someone who invented the little black dress, and it's never failed anybody in a formal affair. That's a do. This is a don't. Don't do whatever this is supposed to be. I couldn't figure it out between my wife and my friends. Nobody knew what this was, but everybody knew it was a don't. The basic considerations for a doctor, if you're going to be recommending medical cannabis, it really depends on what state you're in. California is very kind of loose. So in California, excuse me, there are several listed conditions. By the way, how many of the doctors here, who are in California? Okay, how many, no California doctors? How many, obviously everybody else is from another state. Well, the first thing you really need to do is you need to make sure that you know the rules in your state, because they really do vary. In California, the first medical marijuana state, the rule was, the way that it was put into existence was through a voter initiative called the Compassionate Use Act, and it listed several conditions: AIDS, glaucoma, et cetera, or any condition for which marijuana provides relief, which was pretty vague. Other states is very strict, okay? And so you have to very much know what your state rules are, or you can run into trouble, and that's the whole point of my talk, is so that you don't run into trouble. What kind of history and exam is required? These are the questions you need to think about if you're going to be doing this. In California now, the medical board does not have specific requirements, but it does require, or does recommend strongly, that you get medical records at least relating to the condition for which cannabis use is being sought. So if somebody says that I'll disclose that I have a little bit of ulcerative colitis, right? So when I went to the doctor to get a recommendation for cannabis, they said, "What's your condition?" I said, "I have ulcerative colitis." They said, "That's fine. Have your GI doc send me some records." That's basic. You really need to do that. And if you think that I'm telling you that because people already know that, there's a lot of doctors that maybe know it, but they aren't doing it. And they're running into trouble for that. So you don't want that kind of trouble. What kind of cannabis would work best for your patient? Well, I mean, that's what seminars like this are for. I can't certainly tell anybody really about that. I mean, I've had enough exposure to this industry for long enough, I probably have some pretty good idea. But you come to seminars, you communicate with other doctors, there's literature, but it's not all the same. I mean, the time was, when I was first litigating cases of this kind, the whole, marijuana, it's all just marijuana. How could that help anybody? Well, that ship is long since sailed. It's really a designer drug, and there's various kinds. Excuse me, that last speaker, I had a chance to speak with her before today. I mean, they're literally, and in the exhibit hall where the companies are, selling their wares, they're selling genetic tests to match the patient to the drugs that they're going to use. And that's being done already in some other kinds of medicine, and it will certainly be done in medical cannabis. When it comes to quantities, and I say very general, and the reason for that is dosing. Dosing is like one of the biggest issues. And it's a tricky problem for doctors, both medically and legally, and the reason for that is because you can't really prescribe it in the same way that you do other medicines, because you don't really know when that person, you don't know, when you write a script for 50 milligrams of whatever it is, and they take it down to the pharmacy, you know what they're getting, okay? You know that they're getting the medicine that you've prescribed for them. You can't really know that when they go down to a medical cannabis dispensary. You can have some idea, pretty good idea, now that they've honed the medical production, so you have 6-to-1 and 4-to-1 and so on. But you also don't have the analytical data that you would otherwise have. It just doesn't exist. So you have to be very careful about talking about dosing. And I'm going to probably say this 2 or 3 times as I go along, but one of the things that you for sure want to be careful about saying is that this is what I think you should do. It's better to say, this is what I have found through my patients, through my experience with my patients, to have worked for them. And that makes it, which is, if true, is really what you are saying anyway, but you need to be very careful about how you word your medical orders or your medical advice. Will I ever have to go to court to back this up? Well, you know, let's hope you don't. But you always have to be thinking about that, because you may need to go into court. Somebody that you have recommended cannabis to could get arrested, or I've had this happen, where I've had to represent parents who had their children taken away because a doctor recommended cannabis for their child. The child was smelled like it at school. The children were taken away. Luckily, they got to me. We got the case beat pretty fast, but that's not an experience that that parent will soon forget. And it was a and once we got them back into the home pretty much right away, it was about a 2 months protracted legal battle that cost them a good deal of money and you know, untold amount of stress, and that's not, you know, something you want to deal with. That particular scenario will come up a couple more times in my talk, but the gist of it is, if you're going to say something to a patient and recommend a cannabis treatment to them, you have to keep in the back of your mind, somebody may ask you about this one day, and you may need to show why you did this, why you did it the way that you did it, how much, when, who, etc. Will I ever have to justify my actions to the medical board? And let's hope not, but you might. In California currently, in order to recommend cannabis, what you're supposed to be is you are now required to consider yourself the attending physician, which means you are taking primary care, primary responsibility for the patient's care, at least as it relates to their use of medical cannabis. That doesn't mean you have to treat them for everything. It doesn't mean you have to be on call for them 24 hours a day. It means that you are responsible for their use of cannabis and for being able to explain to the medical board why, for example, this schizophrenic patient that you didn't get the records for and didn't really inquire into then wound up having all of these problems because you didn't pay attention to the fact that you probably shouldn't recommend cannabis to a schizophrenic. That's a problem that 3 of my clients have had before they got to me. So that's something you want to pay attention to. Okay? That's something you want to pay attention to. Do. Remember, we're doing the do's and the don'ts. This is a medical cannabis do. Do get sufficient medical records before evaluating a patient. You would think that that would be just, you know, de rigueur, right? Nobody would ever think about not doing that. And you would be wrong. You can now very easily, you can walk into some dispensaries that sell the cannabis in this state. You can do plink, plink, plink on an iPad that they have in the front lobby, and then you will go in back and they'll say, did you get approved? And they'll go plink, 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 and you will have been approved. You will have never spoken to anyone. You will have produced no medical records. You will have done nothing more than show them your driver's license, okay? There's a word for that, illegal, okay? All of that is illegal, and it's being done. Now you might ask, well, how do they do it? How do they get away with that if it's illegal? Well, you know, I mean, I drove down here from the Bay Area on late Monday, and I was going about 85 miles an hour. I didn't get a ticket. Well, why? You know, just not enough cops to catch everybody that's speeding, and it's sort of the same thing in this business. They just don't police it that tightly, and nobody really reports these things the way that they should, I suppose. And so that's what happens. Excuse me. Don't tell your patient a list of complaints that would qualify and tell them to pick one, okay? I have had 2 doctors as patients who did that, as clients who did that. Somebody came into their office, they said, I really don't want to use, I don't really, have a medical problem. I just want to get an excuse that I can use I can use cannabis. I can smoke marijuana. Okay. Now that was before Prop 64, which made it a lot easier if you're over 21 to use cannabis. You can just buy it and you can possess it. You don't have to have a medical excuse for it. But you can still run into this problem with someone who's between the ages of 18 and 21 in this state, and in any other state, they still have to have a genuinely qualifying condition, right? Well, what happened in these 2 cases essentially is somebody told the doctor, look, I don't really have anything wrong with me. I just want to be able to use cannabis. The guy said, well, look, the doctor said, well, look, I can't give you a recommendation unless you tell me there. So here's the list. Just point to one and we'll write it up that way. Okay? Now, that doctor did that twice, and then the 3rd time and the 4th time and the 5th time that he did it, the people that he did it to were undercover investigators for the California Medical Board. And he was then brought before the board, very serious charges. They had this all recorded, okay, because they were wearing a wire when they were in his office. There were different people. They were very convincing. They're very good at this. And he ran into some trouble. He didn't remain my client throughout the entire process because he was quite indignant about the thing that he was frankly most indignant about was the fact that they had recorded him inside of his office. How could they do that? This is a private medical consultation. This is a violation of my rights and their privacy and so on and so forth. And the only answer to that is, yeah, but how else would they catch somebody doing this without recording? Excuse me. This was a, basically what my grandmother would have called meshuggah, and he just couldn't get it, and he wound up running into some serious problems. But the point being, don't do that or don't do anything similar to that. Just find out what's wrong with them if they can say, and if you feel that there's sufficient records to support it, and if you feel that it's appropriate, then you can recommend cannabis. Do start by recommending the least amount necessary to relieve symptoms. Correct me if I'm wrong. Is that not the basic medical rule for prescribing medicine? How much do I do? Well, if you're not sure, start with the least amount necessary to relieve symptoms. I don't know whether it's visible there, start low and go slow is what it's supposed to say there, and I think that is generally the rule. And particularly when it comes to cannabis, because again, even if you know now, if you can know that you're recommending a 4-to-1 or a 6-to-1 oil or something like that, you don't know exactly how much they're using it. You don't know the regular basis that they're using it on. And the overarching scientific problem, I guess, with recommending cannabis, or the reason it can't really be prescribed traditionally, is there are far too many variables to know which of the variables is at play in changing the patient's condition, either to the positive or to the negative, because you don't know for sure which one of the multiple variables in the chemical itself, let alone their variables, are affecting this. So rather than, the simplest way to deal with that problem is to just titrate small increments and see what changes you get and then evaluate. And that requires infinitely more work than most of the doctors that I know, unfortunately, and have dealt with in this business. There are some very, very good ones, and what they do is they're in constant communication with their patient, emails, telephone calls. It's a lot of work to do this right, and it's not just a matter of, taking the money with the left hand and handing the letter with the right hand and then saying, see you later, which is what unfortunately, many of these businesses still do, at least in this state. Okay, don't use a pre-printed form. This particular doctor was the doctor for a client of mine who got in trouble for how much he was growing. This is recent. This is the kind of thing that used to happen before Prop 64 all the time. And it's still happening in a different way. These are not currently charged generally as crimes in California. This is a civil violation where this gentleman is being, excuse me, they're trying to get multiple thousands of fines against him for how many plants he grew. But if you see at the top, it says he got a 99 plant recommendation, and it can have a certain amount of weight, okay? That's a big, big don't. You can't do that. Because first off, you're not an expert in cultivation. Second, you don't know what strain this person is growing. You don't know how large these plants are, et cetera, et cetera. There's so many things that you simply cannot and do not know that you cannot write it that way. There's a whole legal explanation for the 99 plant letter, which was sort of like the big deal between about 2004 and about 2016. Excuse me, that was all, it's not worth the time to explain. It was all sort of this way to kind of do this little dipsy-do around federal law and state law and medical cannabis. It never worked. Now the other problem, this is a don't. I'm going to give you I guess a double don't off of this one, which is that 99 plant recommendation. That was a pre-printed form. When I asked the doctor about it, I said, so why did you write a recommendation for 99 plants? And she said, I didn't write it. We had two forms. There was the 50 plant one and the 99 plant one. The 50 plant one, that's $145. The 99 plant one, that's $245, okay? Now, there's a word for that. What's the word? Illegal, okay? Very illegal. You go to the doctor. If I had some shoulder surgery a couple of years ago, if I'd have gone to the doctor, see, doc, you know, it's a lot of pain. Can you get me something for it? And he says, well, listen, I can get you the 25 milligram, 1 week Oxycontin. That's the $100. But if you want to go full bore, you want to really roll with this thing, you want the 50 milligram, you want 3 weeks, that's $250, okay? There's a word for that. Illegal, very illegal. And this doctor, when I spoke to her about this, was absolutely flabbergasted. This is what she told me and this was recent. That kind of thing right there, that was a little more common 10 years ago, maybe, right? And I asked her, I said, we were discussing this, and I said, well, look, I mean, I don't know if I can use you as a witness, because now you have a Fifth Amendment problem. If you testify to what you did there, you'll be admitting, your truthful testimony is the admission of a crime, okay? I'm not saying you're a criminal, I'm just saying I can't, as a lawyer, I have to advise you about that. You'll have to get counsel if I'm gonna call you as a witness. She said, really? Everybody does this. She said, this is common practice in the medical business in this state. And I was like, well, okay, well, it's like, what did your grandmother tell you? Just because everybody else is jumping off the Brooklyn Bridge, you're gonna do it too, right? Whatever. Be prepared to back your recommendations and opinions in court. This is a do be prepared. And by the way, I had to get a picture. This is the doctor who testified, the absolutely wonderful doctor who testified in that police murder case in Minneapolis. This is the pulmonologist with that lilting Irish accent who explained what the police did and how it happened. And if you ever want to learn how to testify in court as a doctor, I advise doctors about that too. Excuse me. Just watch his YouTube testimony. It is an absolute textbook. I mean, it is a textbook. And how to handle it, how to say it, how to come across well, how to explain technical stuff well. I mean, it's just genius. It's absolutely beautiful. Don't disappear or avoid your patients when they have a legal issue. The client that I was telling you about, whose children were taken away, the doctor that recommended cannabis to her for her daughter, who was autistic, was an orthopedist who was moonlighting as a medical cannabis doctor, writing letters for I don't know how much a pop. I never asked him that. It took me 4 calls to just have him get on the phone with me and explain why he did this and what he had done. But one of the reasons that this mom's children were taken away was because the Child Protective Service, when this was going on, before they took the children away, called him 4 times. Never picked up, never responded to their calls, okay? So they just figured, he's a schlockmeister, we're not gonna do it, we're not gonna worry about this. And so then they wrote in their affidavit for taking the children, the warrant that they got to take the children, they said that she had not consulted with a medical professional, even though they had a written copy of the recommendation letter, they assumed, they just said later in court, they thought it was fake. They didn't, the doctor never followed through, never called them, et cetera, okay? Not to mention, excuse me, just as an aside, this is the #1 complaint when it comes to lawyers, and doctors in that sense are probably not terribly much different in this regard. The #1 complaint since I've been practicing law, every time I go to one of the continuing legal education seminars, how to not get in trouble with your clients, return their phone calls, return their emails, be responsive to them. Some of the clients that have liked me the best and sent me the best referrals are not necessarily the ones that get the best outcomes, but they're the ones that felt like I cared about them, that I actually, and I do care about them, but I'm saying you have to respond to them. So please, and even if it's not just for a business, from a business standpoint, your patients can get in trouble. And if they don't get, if somebody who's looking into their status doesn't get through to the doctor, that can be a problem. Do evaluate the patient's needs for cannabis. This one's a little bit repetitive. When I was putting this together, I was working with my son and he was teaching me PowerPoint, and I tripped a couple of times. But this is about getting medical records. That should be the first question you ask when someone calls. Can you send us records? I have a very good friend who's a pretty prominent cannabis doctor, and the first question that their staff asks when somebody calls is, when can you send us, or to the effect of, can you send us your records? And if they say they don't want to do that, they just say, thank you, we can't help you. Okay. You get the records, you look through them, then you make the appointment, then you go from there. Don't recommend specific amounts unless it is required in your state, which I'm not aware that any state requires doctors to prescribe specific amounts of cannabis, but otherwise don't, because you can't really prescribe cannabis in the same way. You just can't do it. There isn't the analytical data, there are too many variables, and there are too many variables in the product that may end up in the hands of your patient. So it's all about start low, go slow. I'm going to shift gears a little bit to driving. This always comes up when I give this talk, or something similar to this talk, about driving. Don't fail to advise your patients on the effects of cannabis combined with alcohol or prescription drugs for driving, okay? Don't do that. Cannabis itself, isn't necessarily all that damaging when it comes to driving. In California, one has to be considered impaired, not just under the influence, but impaired if they're driving, and there is a difference. Under the influence means that the medication or drug is having its intended effect. That is not necessarily impairment. The general, let's see if I got this in the right order. Okay. The general admonition that doctors, and please correct me if I've got this not quite right, but this has come up in my court cases. The general admonition to doctors to give a patient about driving is, with the exception of alcohol, which has a per se limit, a blood alcohol concentration that everyone agrees, at least legally speaking agrees, is unlawful to have in your blood when driving. That's not true for cannabis. It's actually not true for any drug. In California, for example, it is unlawful to drive under the influence of alcohol, any drug, and that includes prescription medications, or the combined effects of alcohol in any drug. So, but when it comes to a drug, if it is having its intended effect, you are not presumed to be impaired, okay? The general way in which the courts have now ruled, the way in which to determine whether someone is genuinely impaired by a drug is primarily by the way that they are driving. And then if it actually involves a police officer called a drug recognition expert who has to do this kind of complicated exam. When it comes to cannabis, there are largely only 2 sobriety tests that are supposed to really matter. One is lack of convergence. So presumably the doctors know what this is, right? It's as an object moves toward your eyes, they're supposed to converge, and if they don't converge just right, that's evidence that you may have cannabis on board. But I guess it's also the case that something like 25% of the population has lack of convergence anyway, so it's maybe not all that conclusive. The other one is called the slowed internal clock, which means that what they typically do is they have you close your eyes and estimate when 30 seconds have passed. Oh, okay. Close your eyes and have you estimate when 30 seconds have passed. If it takes you too long, then they can say that cannabis may have caused that. That's consistent with cannabis use. Do familiarize yourself with the laws of your state, their states meaning doctors, on the possession and use of cannabis. Don't think that an hour or two of legal consultation is too expensive. I'm not saying this for myself. I do mostly criminal defense. I've been around long enough, I get pretty good fees from people that do really twisted stuff, so I don't need to worry about consulting with doctors all that much. So this isn't some sort of advertisement for me. This is for your own good. Just, find a good lawyer and wherever you practice medicine, and just, pay for a couple hours of their time, an hour or two of their time to make sure that you're not, bumping up against the law, because the law is an unfriendly cat. Don't give legal advice to your patients. Boy, oh boy, the doctors I know that do this, that I do consult with, they're constantly saying, well, what can I tell my patient about the laws and what's legal for them to do? And the answer to that is nothing. You have to refer them to a lawyer. You really can't give legal advice. That's a very dangerous game to play. Refer them to a lawyer. You can, if there's published material in your state, which there probably is, certainly refer them to that, but do not give them legal advice, even if you think you know you're right. Even if you think you know you're right. Do tell your patients what you have found to be effective in your practice for your patients. That's the best way to prescribe it or to recommend it. Is don't say this is what you should do. In California, for example, it's extremely tricky because doctors are not allowed to have any financial relationship with any producer or provider of cannabis. So you can certainly run into trouble if you start going down that road. So just say, this is what I have found, my patients have found to be effective. Don't recommend specific amounts. This is one of those somewhat redundant ones. Oops, did I miss one? Do understand the difference between hemp and marijuana. The long explanation is that the FDA has not yet approved or given its signature to hemp for medicinal use, and that's why when you hear those ads on the radio for it's legal in every state and it's the greatest, blah, 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 what's that last tagline? This product is not intended to diagnose, treat, or cure any medical condition, okay? If it is being advertised as a medical product, as a health-related medical product, then there's a word for that, illegal. And the FDA has not approved this yet. They're not policing it because, like when I'm driving 85, they just don't feel like it's something they're going to expend that much. And they feel that eventually they will, and they're changing their rules, but right now they haven't. And everybody knows that marijuana is the plant with 3% of THC, Delta-9, et cetera, et cetera. And there is a difference, but that farm bill that everybody thought, just turned the world around, and not yet. We're not there yet. Don't think that hemp is legal to buy and sell as medicine. I think I've already covered that. Do understand the difference between clinical data and trial data. Clinical data, and I'll let a doctor correct me if I'm wrong, clinical data is your experience with your patients. Trial data is what pharmaceutical companies produce through double-blind studies, which really haven't been done with the exception of a couple of medications that are currently approved. Do realize that with medical cannabis, what you do is more art than science. I remember when I was a little kid, my pediatrician, I remember seeing this sign that said medical arts building. And when I got older, I used to take the bus by that building, and I thought, medical arts, isn't medicine science? Well, there's a lot of art to this practice of medicine, and particularly when it comes to cannabis, because the science is limited. But that doesn't mean that a good doctor can't practice in this regard. But you have to, kind of get a feel for what you're doing and have a feel for your patients. Do finally, ultimately make the ultimate standard, the thing you'll have to answer to for the medical board in court, whenever you have to ultimately answer to it, is what is the standard of care. And the standard of care is nothing 100% set in stone. It's what an expert in your field would say it is and what would be this agreed upon standard of care. Excuse me. I think probably most people know most doctors know what it is. It's some intuitive level. You get records for people that you're going to look into. You stay in contact with them. You follow up. You make sure that you don't over-recommend or over-prescribe. You don't ignore your patients. I feel like I'm my grandmother telling me what to do, but that's what it is. You know, sometimes for myself, my standard is what would my grandmother have said I should do? And that's a pretty good standard, and it probably works most of the time. You know, it's common sense, but it doesn't always, you know, in any particular situation, you just have to take a step back. What is the standard? What do I feel comfortable with? What would I want someone to do for me? What would I expect others to do for me? So I made it, 30 minutes.
Hi, Michael. Thank you.
Sure.
I'm not a doctor, but I play one on TV. I'm also the co-host of a podcast with Chella. Cannabis Helps Dementia. I think she spoke to you last night about Ryan's Law.
Ryan's Law.
And RCFEs. And could you speak to Ryan's Law in California? And is it going to help us get cannabis into RCFEs, or is it specifically 6 months to live? Hospice?
Well, the 6 months to live part, I'm not.
Okay.
It is hospice. The 6 months to live, I think it's 1 year, actually, is the.
Okay.
So Ryan's Law is a law that says essentially that the state passed a law that says that hospice providers are now required to allow the use of cannabis by patients who are in hospice. I didn't look up the time factor, but I believe it is if they are terminal, which means 1 year predicted life based on the current prognosis. The provider is required to allow the use of it and to create a protocol for how it's to be used and distributed. The other big requirement is no inhalation of cannabis is allowed, so no smoking and no vaping.
Interesting.
So it has to be orally consumed, which means either an edible or an oil.
Right.
And that's it. Now, if someone's sick and in hospice care in California, they almost certainly have a primary caregiver, which is someone who cares for them. That's the person who's going to be buying it and bringing it to them, or finding it or growing it and bringing it to them. That would have to be allowed. They'd have to allow a primary caregiver to bring it onto the premises. A primary caregiver is also someone who administers it, which is, there's a whole legal definition of administering it, but more than likely in this scenario, if someone's pretty sick, it means putting it on the spoon and giving it to them, you know. Right. The hospice personnel are not required to store it or administer it, but they are required to allow it.
Got it.
So I hope that's a pretty good explanation.
Yeah, thank you. Thank you.
Sure. Okay.